that was signed by two attorneys, practicing attorneys who know the law. Quite simple, counsel. Mr. Del Casal is not to post, repost in any way, do any actions in an attempt to disparage the other party in this matter. And if it happens again, Mr. Harris, and if in fact it is true, Mr. Needham, your client will be coughing up money. Page 1, A18-781255, Harris versus Del Casal.
Morning, Your Honor. Kurt Harris on behalf of the plaintiffs.
Good morning, Your Honor. Attorney Al Needham here for defendant Del Casal.
Good morning, Your Honor. Attorney Charles LoBello here on behalf of the defendant Michael Franklin, bar number 5052.
Thank you. This is a motion for an order to show cause. Counsels, I guess, let me see if I understand correctly. There was an order based upon a stipulation and an agreement, and now one of the parties is saying, I don't have to abide by it. Let's hear from the plaintiff on this matter.
Thank you, Your Honor. This stipulation was signed on November 6th, 2019, and filed December 10th, 2019. In that stipulation, it was signed as a compromise in order to avoid the issuance of an injunction against the defendant, Del Casal. This was a compromise that was struck in court. It was agreed to by all the parties. In that stipulation, which I insisted that Mr. Del Casal sign personally, he stated that he agreed not to publish or republish any negative content regarding my business, and he also, or anything, repost anything which might create or cause any business disparagement. On July 12th, 2021, he published a negative post that is believed or would appear to cause business disparagement because there is no other legitimate purpose for the posting. On July 30th, 2021, I deposed him to ask him directly if he was the reposter or the author. He indicated, I posted it, sure. And that is a quote. I posted it, sure. Following his deposition, we filed a motion for an order to show cause based on NRS 22010. Mr. Del Casal is aware of the order. Mr. Del Casal signed the order. Mr. Del Casal has been signed with the order. The order was written, and he knows the expectations, and he violated the order. He admitted he violated the order, and at this time we're asking that an order to show cause issue, Your Honor. With regard to the opposition, it is my opinion that NRCP 65 does not apply to written stipulations. It is my opinion that Danberg neither applies to a written stipulation in order where the parties agree to be bound. Moreover, I think it is very troubling that counsel now indicates that the stipulation and order are invalid because of no bond requirement. That is wholly wrong and improper, and I believe it is sanctionable to raise it at this time, given the fact that that was a stipulation order that was entered into the parties voluntarily. They'd never moved to set it aside, and they've never made any other inquiries in regard to that. He was served with it. He's aware of it. Saying now that somehow it is invalid because it lacks a bond, that's wholly inappropriate. In addition to that, we didn't require a bond because it was a maintain the status quo stipulation. It didn't go beyond that. They weren't being restrained from doing anything other than just not causing any disparagement. And so it is wholly inappropriate to raise the bond issue at this time, Your Honor. We're asking that an order to show cause issue and that we can have a hearing on this. I know that Mr. Del Casal has already admitted the conduct, so I'm not really sure what he'll be prepared to say, but we're asking that that be the order of the court, Your Honor.
From your side.
Thank you, Your Honor. In regard to the stipulation in question, the dates, this was about, roughly 2 years ago. And
I got document right in front of me. It was signed November 6th, counsel.
I have it right. And there's that phrase that comes to my mind that hindsight's always better than foresight. And here's what I mean by that. If we look at the stipulation that's in front of you, Your Honor, it says on page 2 at the top, specifically the parties agree to maintain the status quo. And that includes Mr. Harris. And in the spirit of this is not for Mr. Harris continue disparaging and defaming Mr. Del Casal, which he's done from day one. for almost 3 years now, and yet at the same time he's here in the court saying, oh, well, I don't want Mr. Del Casal to say anything about me. That's just not fair. So,
Counsel, save the he's doing it also argument. That's not before me. What's before me is a motion on an order and a stipulation that you're now saying is invalid, that you as an officer of the court signed. You agreed to it. So what you're saying is you and your client agreed to an improper order?
no, what I'm saying is that this affected both parties. And I'm saying that the interpretation of it, this involved a web page. A web page. That's what triggered the motion for temporary restraining order in the first place, a web page. That Mr. Del Casal did not create. That's what led up to this stipulation. Mr. Del Casal's interpretation is that this didn't affect him to that in regard to anything beyond the web page, which, as I understand, has been taken down. One thing that happened too, as I mentioned in the opposition, subsequent to this stipulation, there was a hearing in front of the court, and I believe I think it was December 12th, where Judge Baer had indicated First Amendment rights, and specifically in regard to Facebook pages. Now, the post that's been attached to the motion is apparently from a Facebook page, and it's not just an ordinary Facebook page. It's in regard to family court news. Family court news apparently is where this is taken from. And then I look at the post, and it seems to me like it's a review from another person, a review, and it seems to be focused on someone named Scott. All right, and Mr. Del Casal appears to have, I guess on Facebook you can share a link, so it's not really directly his post. So there is a issue in regard to whether this, as far as the violates the stipulation. My thoughts were this: when I got this motion, I thought, geez, I would have appreciated if counsel would just contacted me, but he didn't. And then they just filed their motion, but I lost my train of thought there, Your Honor. And I think I have another
Counsel,
point.
let me cut to the chase here. It's real simple. Okay, we have a document that all the parties, including counsels, signed off on. They said we agree with Judge Baer that that's a good and proper order. We want that stipulation. And now what we're doing is we're getting an argument that, well, maybe that's not even a valid stipulation, and we really didn't know the terms of it, and it's vague and ambiguous. And I'm getting all these contractual arguments in regards to a stipulation and order that was signed by two attorneys, practicing attorneys who know the law. Quite simple, counsel.
But yeah,
Mr. Del Casal is not to post, repost in any way, do any actions in an attempt to disparage the other party in this matter. That's the order that was set. I am not going to, at this time, do an order to show cause, but it's quite simple. It's here, Mr. Harris. If they repost again, please assure yourself, Mr. Needham, or assure your accounts or your client that then Mr. Harris will file this motion on an order to show cause. I will grant that motion to show cause, and I will sanction your client in regards to that. So the motion to show cause is denied in regards to that, other than the court order that the parties are to continue to abide by the terms that they agreed to and not violate them in any spirit, in any way. And if it happens again, Mr. Harris, send me a motion, do it on an OST. We will hear it as soon as possible. And if in fact it is true, Mr. Needham, your client will be coughing up money. Is my point clear?
Yeah, right, Your Honor. Just one simple thing. The concern I have is that, it's that Mr. Harris continues in his papers to continue attacking Mr. Del Casal, but he wants Mr. Del Casal not to say anything. I just find that not really professional or fair to do that.
I understand, counsel, but counsel, that should have been in part of the temporary restraining order that they agreed to.
And I agree with that. I think that's why I'm thinking in hindsight we were trying to be fair with Mr. Harris. Didn't expect him to continue attacking my client and then expecting my client to shut up. We got a hearing on October 5th, Your Honor, a motion for summary judgment. I think it'll affect this issue, and it may resolve the case.
All right. Well, thank you. Well, I'll wait for that motion. Mr. Harris, prepare the order on this matter. Counsel, I need to cut you off. I've got a jury standing outside my door.
Thank you.
Thank you.
Thank you.